So Mike Rappaport, Ilya Soman, and then Steven Sachs. In that order.
Okay, so I have 2 points relating to the 2 parts of your paper, Jamal. Although first I just want to mention, since Mike mentioned this interview at OLC, people seem to remember all kinds of things at these interviews at OLC. Someone once accused me of throwing a constitution at them, which I don't actually think happened, but I'm happy to embrace the story. But I will say Mike, who I was with in law school as well, was, now I know why he was so motivated, about to become unemployed, was the best darn interviewee we had. I mean, it was incredible how Mike was able to just answer those questions. Where did you learn this, Mike? I didn't learn it at Yale. Anyway. Anyway, so my 2 questions. So the first part relates to the first part of your paper, where you talk about this incorporation issue. And I guess I have sort of a different sense of it all. My sense is that the leading view among scholars these days, Mike, Paul said maybe to the contrary, maybe not, is actually that the content of the rights may be different under the 14th Amendment. I even think Mike's obviously willing to recognize that in certain respects. I think so I think that's the leading view. There's a lot of scholarship, or at least some scholarship, that I think you might want to add. The first thing that comes to mind is Ryan Williams's piece in Yale, which is really quite significant. Much less significant is a paper that I did, arguing that the takings clause has a different meaning at the time. And I think actually in trying to understand why we don't see as much of this as we might, the explanation that I would give is, first of all, we really have to give credit to Akhil Amar, kind of for really sort of seeing this point and arguing for it in an incredibly persuasive way. But that only happened in the 1990s, right? So it took some time for people to kind of digest it and figure out that whether they agreed with it or not. So the scholarly process sort of moves slowly. Some of the stuff that you cite, actually I think a lot of it is pre-Amar. Mike McConnell's piece on religious liberties, 1990. And the other thing about it is I actually think it's very hard, so take, does the 4th Amendment mean something different under the Privileges or Immunities Clause than it does in 1791? We're so far from understanding where the 4th Amendment means under the original Constitution that, that's a hard job. We got all the different clauses. We're just, there's been 50 to 100 years where originalism has been largely ignored. So now we're sort of doing the job, and understandably people look at the core, the original provision first before they get to the 14th Amendment one, because it's to some extent derivative. So that would be the explanation that I would give for sort of why we don't see as much of this maybe as we ought to, but I do think it's the leading view theoretically. The second point, and I can be briefer here, is in the second part of the paper you say, well, there's these narratives that are not persuasive, and I sort of get it in a way, but part of me sort of resists it. So there's the notion that the 14th Amendment was a failure, and I agree. In its time, it did some good stuff, but largely was a failure. But I'm not sure that's a problem for the narrative of originalists. So in my own work with John McGinnis, we say, yeah, the original meaning of the 14th Amendment was ignored. We got Jim Crow. You know what? Jim Crow is the results of non-originalism. I don't think is that an unappealing narrative for originalists? I think not. I mean, at least I don't. So I'm kind of wondering whether what accounts for persuasive narratives and whether there really might be more here for originalists under the regarding the 14th Amendment.
Okay. Ilya and Stephen, and anyone else?
So I was referring to part of your paper which discusses the Bill of Rights and whether or not it changes during Reconstruction, and I think you maybe overlook, or at least don't give sufficient attention to, a sort of very basic intuitive reason why, until Akhil Amar's path-breaking work, people didn't really focus on this, maybe the meaning changed, and that is that there's sort of an intuition that if we sign a contract and we say, well, we apply to us these rules that previously applied only to a certain other group of other people, and that's part of our new contract, they're applied to us, sort of the intuition is that the rules that we're applying are the same ones that existed before would reference those other people. And I think that's a very powerful intuition. It's sort of common sense. You don't have to be an originalist to have that view, by the way. And I think the intuition could be wrong in particular cases, and Amar, I think, did a good job explaining why it might be wrong. But to this day, many people share this intuition, and not just originalists. Let me sort of wait to a brief experience that I had. As some of you know, I'm in the process of writing a book about the Kilo case and its aftermath, and one of the chapters in the book is going to be a discussion of the original meaning of public use. So in my book proposal, I said, well, we need to look at what it is in 1868, not just 1791. After all, most takings, including Kilo, are state takings, not federal takings. And to my surprise, there actually is not an article in the literature about the original meaning of public use in 1868. I'm going to, and when I write chapter books, it would be the first one. When I sent the book proposal out for reviewers, although it was accepted and I'm going to be published a book, two of the reviewers said, well, why is Soman accepting this sort of controversial theory of what the Bill of Rights might mean? It doesn't really make any sense. It means what it said at the time. And I don't know who the reviewers were, they're anonymous, but my impression is that they were not, at least one of them was definitely not a conservative or an originalist or whatnot. So I think this is an intuition that is shared by people broadly, including by many non-originalists, including, as my experience shows, some academics. Second, and very briefly, sort of your distinction between the redemption narrative versus the restorative narrative, it seems to me that there is a restorative narrative that can be told about the 14th Amendment and Jim Crow and the like, that, we restore the original meaning and therefore do away with the falling into sin of Jim Crow. Not only can you tell this, but such figures as Martin Luther King in his I Have a Dream speech actually do have, an approach like this. I can't remember the exact words, but there's a famous passage in that speech where King discusses sort of the idea, the promises made at the time of Reconstruction of the 14th Amendment, how they were broken, but how we then need to sort of live up to them, right? And now I think it was a powerful narrative at the heart of the civil rights movement. To be sure, conservatives at the time who were inclined to be originalists did not accept that view, many of them, but I think that's a flaw more in the sort of conservatives of that particular era, and to some extent some of their ideological descendants, than it is a flaw than it is a statement that originalism, you can't have sort of a restorative narrative that fits very well with that particular issue.
Yeah, rise up and live out the true meaning of its creed.
Yes, thank you for that.
Stephen Sachs.
I want to say that I again really enjoyed the paper and thought a large part of it was true, even though I ended up feeling like I disagreed with it. And so so I think, for instance, your point on sort of the narratives, I think, is sort of 75% right in that, and as you pointed out, like in part, there's largely a generational shift. The early originalists, people like Royal Berger, were arguing from a certain perspective, whereby to them, sort of incorporation was the latest delusion by non-originalist scholars. I don't think there's anything that sort of Michael Kent Curtis or someone who thought like them would disagree with in that discussion in your paper about how a lot of people, so the Fairman school and the Dunning school sort of had very long-lasting effects. I think that's surely true as a just sort of sociological matter. And I think that, moreover, I think you're probably right that the fact that the 14th Amendment deals in abstract principles was a reason why people who were coming out of that school were less likely to sort of seize hold of it and adopt that as a focus of their efforts. But I want to point out that there's another explanation that might persist to the present day, which is just that 14th Amendment is really hard. It's, academics, just like everybody else, go for the low-hanging fruit first. And it's just a lot easier to do stuff like, I worked on the full faith and credit clause because, I'm one of, 5 papers that talk about that using the same sources. So there's a lot more to do there. It's a lot, it's not nearly as difficult as the abstract and very complicated principles. And in particular, the fact that it was a failure at the time makes it even harder because the abstract principles are not cashed out by facts on the ground. Instead, what you had was, essentially a campaign of massive resistance, from the Supreme Court on down. And that makes it really hard to extract, accurate original meanings. So I think that might be a sort of disincentive to academics even who are not tied to sort of the Dunning School approach, let alone judges, who Lord knows after they adopt these things then actually have to implement them on a case-by-case basis. The final point I wanted to make, though, is that even though I think those things are right, I worry that the sort of paradigm case for your paper is, did the meaning of or do the Bill of Rights apply in a different way to the states as to the federal government? Because it seems to me there's a tension between the assumption that they must have and the later discussion of the distinction of, framework originalism, or, the difference between meaning and original expected application, or you could call it the sense reference problem. But you could think of ways in which sure, some things come in as privileges and immunities and other things don't. That's why it's only the first 8 amendments, and not the 10th. That's why it's, maybe, Justice Thomas has speculated on whether the Establishment Clause comes in because maybe that was a federalism provision too. Things that were not privileges and immunities don't come in. But you might also think of it the way Ilya described in part as sort of an incorporation by reference, that when we say the privileges and immunities, well, what it is to be a privilege and immunity, we look to 1868 to answer. But what those privileges and immunities actually were might be determined by facts external to the text, and that might be the rights you actually have under the Constitution vis-a-vis the federal government, which might then require reference to 1791. When you say on page 6 that this is not a plausible interpretation of the 14th Amendment, nor have I ever seen it articulated explicitly, it was the only one I thought anybody had until recently. And it sort of took, so I think there's a broader range of interpretations there than your paper admits. And likewise, I'm not sure that it falls victim to the criticism on page 7 that it's unthinkable that the Civil War generation believed itself to be delegating interpretation to the Bill of Rights to federal judges. I don't know that that necessarily is true, because you could think that what was incorporated is what the rights actually mean. Federal judges, just like everybody else, have to figure out what that answer is and follow their best lights in applying them. But it doesn't mean that federal judges determine the content of those rights, or even to the extent that they are trying to figure out what the 1791 framing generation thought.
Okay, that's a lot of stuff. That's really 4 people, because there's Mike as well. And I'm not going to get to everything, or maybe even most things, but I'll just point out a few points that occurred to me. So one, as to Mike's point, as to these 2 options here, I guess in terms of incorporation, I agree that one of the problems is we don't know which of these is correct. My own sense, and I gathered that this is from Mike Rappaport's comments, that this is closer to a scholarly consensus, is that it is closer to the second than the first. But one could disagree with that. I think that doesn't undermine the point that one still needs to engage in the inquiry, which I think never. I mean, it just doesn't. Obviously, there's path-breaking work. Obviously, Akhil's work is very important here. But simply to say that, well, we're going to look to 1788 or 1789 or 1791. Well, 1791 is what's relevant for the Bill of Rights, because we assume that the answer is going to be about the same, seems to be much less rigorous than most of what I tend to see in descriptions of original meaning originalism. I'll tell an anecdote from when I was on the job market. And my job talk paper related to originalism, and in the course of conversations, I would refer to the meaning of the Constitution as of 1789. And I was corrected forcefully by someone who said, no, it's 1788, because that's the year when New Hampshire ratifies and becomes the 9th state to ratify the Constitution. That's the relevant year, right? If we care at that level of detail, then I think we have a real problem in terms of the way in which we, in fact, practice originalism with respect to these rights, where we actually think that that's the really important year, and I think that that requires a stronger justification than I have seen. Now, just skip ahead a little bit to what Stephen said, which I think is very important. I do have my paper here. So the sentence you quoted, I think, didn't end with that with federal judges. I don't think it did, but maybe it did. It is unthinkable that that generation believed itself to be delegating interpretation of the Bill of Rights as applied to states to federal judges to determine how 18th century Americans would have understood its protections, which did not at the time apply to the states. That last part is the part, not the federal judges part in and of itself, but that last part is the part that I find much less plausible, which is that that in fact when we enact the Privileges or Immunities Clause, we are enacting it on the understanding that it will not be interpreted as we currently understand privileges or immunities, but it will be interpreted as federal judges in the future understand specific rights in the Bill of Rights as applied to the federal government in 1791, but actually as applied to states. That I think is a stretch, and if that's the move that we're making, I think it requires more justification than I've seen. Now. What else? So the fact that it's very hard, I agree, and I think that that is surely part of the answer here, and maybe a big part of the answer is. But we have a practice that seems intuitive, as Ilya says, that seems intuitive, that seems to make sense, that is consistent in a lot of ways with the way that judges, because of the way in which incorporation works its way into doctrine, that judges are going to be reasoning in this way. And so we're going to provide some source material, right? Academics are going to support the judicial enterprise. And so the questions that come up are the way they're going to be resolved in practice is not in this sort of pure way that I'm suggesting, but in a less pure way, in an adulterated way that sort of has a hybrid sense in which it refers to 1791, but it's essentially a kind of legal fiction that we're going to apply those exact same original understanding to the states. And I think that precisely because the things that we tend to write about, the pressures exerted on academics to write things, are motivated by the pressures of adjudication. That you're going to see lots of work that looks like the work that I'm criticizing, and so I actually agree with I guess it was Mike that in its purest form, original meaning, originalism is a theory of exegesis, and so a lot of the sort of what you say psychotherapy that I'm engaged in sort of misses the mark, but I actually don't think that. So let me back up a bit. Actually, I part of the reason for writing the paper was actually in some ways a response to Jack, which is to say that when we talk about originalism, we talk about a phenomenon that has a range of meanings, and Tom Colby has done a lot of work on this, that we often tend to conflate, but that actually means something quite different in public discourse, means something quite different for academics, means something quite different for practicing lawyers. And so there is a practice that the public discourse is certainly engaged in, that I think judges are certainly engaged in, and that many academics have been engaged in for a long time, that is centrally concerned with adjudication, not centrally concerned with exegesis, and that does suffer from some of the, some of the effects. I was going to say pathologies, but that's too pejorative. Some of the effects that I talk about in this paper. I do think that there are good faith academics working on originalism who are doing public meaning originalism who are not susceptible to this. And I think you're in the minority in the sense that you actually prefer Bingham to Jefferson. That's a very academic view. It's not a view held by very many people, which is why you had to apologize to the camera when you called Jefferson a scumbag. So,
don't repeat it.
oh, sorry.
But he was.
So the point, I just mentioned this in the paper, part of the point is that I think as originalism works itself pure, right, you might see a lot more writing in the vein that I'm talking about, but I still think there will be a phenomenon that's worth talking about, which has to do with using originalist arguments, using historical arguments as a form of authority that are still going to point in this direction. So I think one test will be, okay, I've made this argument. There are lots of people writing about the 14th Amendment today, hopefully lots more in the future. 15, 20 years from now, do we see originalist judges actually making these moves? Do we see public discourse actually making these moves, or do they stay really stubborn? And if they stay really stubborn, then I think I've still identified something relevant. And as I say in the paper, I actually think that at some point we will, if that in fact happens, we might just need a different name for originalism. Maybe we'll go back to strict constructionism or one of these other terms that's meaningless. But I think it's capturing a phenomenon that is important, that exists in the world, and that academics are maybe doing something else.
Okay. I just have to say, I would infinitely rather teach at the John Bingham School of Law than the Thomas Jefferson School of Law. But it wasn't up to me to name it. I'm a big admirer of Jacob Howard from my home state of Michigan, too. I've always liked him. The queue is already on far longer than we'll be able to reach everyone, so I'll have to not add additional people to it. And I'm going to take the liberty of identifying the next 4 people, because Jamal did a great job of replying to 4 there, and I apologize for jumping in, but just in the interest of moving along, try to be as concise as possible. The next 4 people that I had were Larry Alexander, Mark Tushnet, Andrew Kent, Garrett Epps. So a nice little balance there, Larry.
Yeah, well, I read the paper as a 2-part paper. One part is what I would call an internal originalist complaint. You know, there's this problem about the meaning of incorporated terms in the 14th Amendment. Hasn't been dealt with nearly sufficiently. It's a real problem there. I view that as a sort of internal complaint. But then there's a complaint about originalism, or at least, you know, if not, it's surely implicit through the paper, and I didn't, you know, I guess as someone who subscribes to it, because I think I have this simple-minded view that laws are, you know, communications from lawgivers to their audience, and you react to them as a communication. If there's an old communication, then you look back to what, you know, you look back in history. But it's an empirical thing. What did they mean? And sometimes you'll be gratified to find what they mean. Sometimes you'll be, you know, sometimes you won't be able to find what they mean. Sometimes you'll find what they mean and it's very displeasing. You wish they hadn't meant that, but they do. And so you know, so a lot of the paper seems to be, in Mike Paulson's words, putting originalists on the couch, and sort of the idea that it's really not a good faith method. It is result oriented in various ways, and when originalists find, you know, things that, you know, aren't pleasing to them politically or whatever, they tend to ignore them or, you know, pretend they're not there. Well, that may be true of some people. What always seemed much more interesting, you know, sort of as a social psychology, is non-originalism. You know, so what is it about it's sort of like Constitution fear, right? You know, it might mean something that we don't want. And that always seemed to me more psychologically interesting question. Why do people want to ignore the Constitution, right? you know, it's surely nobody's perfect constitution. Surely wouldn't be the one I would draw up. But, you know, it seems to be something that we can rally most people around, and so it works nicely. You know, it's not too bad. Actually, most of the important questions today, I suspect, if the Constitution is read fairly, are left open to the political process. I don't think the Constitution actually stands in the way of much at all. But it's surely not perfect from my standpoint. I doubt it's perfect from anybody's standpoint. But the question I always have is, well, what's the motivation of people who are not originalists? I mean, you know, I'm trying to figure out what the document means, and I've never quite understood what the alternative is. It's sort of like we cite it to so the court can cite it to trump laws that it doesn't like, but it's really, there's no there, right? It's not, there's no reality there. So I want to turn the tables back. You know, what's going on with rejecting originalism?
Mr. Mark
I have the part one and part two in Mike's comments. The part one point is just on, as an example of a possibility where there might have been some change of a certain sort, is, just to do it in shorthand, from Heller to MacDonald. That is, the Second Amendment argument as a Second Amendment argument is close. Scalia probably has it right, but it's a close question. As of 1868, it's trivial. I mean, you know, everybody knew the individual right thing was what okay, so it's not quite perfect because it goes from a close question in favor of an individual right to an overwhelming case in favor of an individual right, but there is something different in 1868 from 1791. Okay, the part two is, this is the Center for the Study of Constitutional Originalism. There's this phenomenon, constitutional originalism. Let's study it, right? Right? As opposed to, let's do it. I mean, that's, you want to do it, it's fine, And I'm not saying the center shouldn't encourage people to do it. I mean, it's within the remit and so on. But saying, like, there's a connection between the rise of constitutional originalism and the rise of conservatism in the Republican Party. It's not an irrelevant observation. Or just to, in the story, in studying constitutional originalism, it might be interesting to look at the hiring practices of the Reagan-Bush Office of Legal Counsel, Bush's Office of Legal Counsel, and the networks of support that derive, that arise out of that, and so on. So, when you do that sort of thing, or another way of putting it is, you folks, I'm distancing myself from this, you folks have become objects of historical study, not merely subjects who are engaging in the practice. It's happened to me with respect to critical legal studies. I mean, it's, people interview me to talk about what was critical. Okay, and fine. It's not critical legal studies, but, it's okay.
All right, we have Andrew, Kent, and Garrett absent. If you give Jamal any time at all to reply, it's got to be about 1 minute each. So.
I guess second, what Mark Tishner is saying, I think this is terrific to have an external perspective on such an important phenomenon in the academy and in the courts, in the public. I think it is uncomfortable for the studied. In a volume that Mike Ramsey co-edited that came out recently about international law in the Supreme Court, John Witt, the legal historian at Yale, has a terrific piece about how law professors talk about international law in the Supreme Court. And I know for a fact that the law professors examined found it quite uncomfortable, but that doesn't mean you shouldn't keep doing it. I think it's a sign of increasing methodological sophistication in the law schools that we have projects like this. I think it's great. the second very small point, but one reason why the 14th Amendment might be, sort of ignored somewhat I think goes to the way that it became part of the Constitution. In the same way that we don't talk about what Rhode Island and North Carolina thought about the original Constitution because they rejected it. A large part of the country, had no choice but to adopt the 14th Amendment. It was forced on them as a condition of readmission. Essentially because of military reconstruction. And so, to the extent that originalism is kind of looking for, broadly shared, public understandings, a lot of the country just didn't accept the 14th Amendment, but had no choice but to take it. And so that, might be, I'm not saying this is an overwhelmingly important reason, but in addition to lots of the other things that you mentioned, that might be another reason why it's not studied as much by originalists.
Karen.
Yeah, I'll just say very quickly, again, I completely agree with the idea that studying originalism and trying to figure out why it falls short of, and very often I think it's not very good at addressing post-1789 events generally, is worthwhile. I do think that there is more 14th Amendment originalism than your paper gives the professoriate credit for. And ironically, a lot of or maybe it's not ironic, maybe there's some causal connection, but a lot of what has really been very hot 14th Amendment originalism in the recent years concerns a provision that I would argue was not a failure, succeeded almost right away, and that's the Citizenship Clause. And that is not only being debated in law review articles that I think would be worth looking at for you, but the rubber's meeting the road in legislatures and city councils. I've been involved in standing up and talking to state senators and mayors and so forth who say, well, clearly the original intent of the Citizenship Clause was X. So I would think your paper would be bigger, and I think it's interesting to think about the fact that the Citizenship Clause did have a different kind of impact than the other parts of Section 1, and think you might want to take a look at that.
So I'm afraid I'll have to give you a few minutes to reply. We haven't been giving you enough chance, but see if you can sum up.
So I'll say just a couple of things. One, in response to Larry, just one thing I would say is that the suggestion of the paper is not that what's happening is result-oriented or political in a narrow sense. The suggestion is that the sources of authority have different stakes, and for reasons that are, in fact, I think external to originalists themselves. The stakes of the 14th Amendment interpretation are very different than the stakes of founding era interpretation. And in fact, I think this is not just a problem for originalists. I think it's a problem for people who are not originalists as well. But I think the stakes are higher for originalists because originalists claim that the normative claim is that there's a transparent, stepwise, more objective form of interpretation, and so if an inconsistency is identified, it's a bigger problem for people who pride themselves in consistency. Just to a brief point on Mark and McDonald and Heller, which I do mention in the paper, which I think is actually in some ways a doctrinal exception to a lot of what I've said, because the analysis in McDonald is very much focused on the understanding of the right as of the 1860s, not as of Heller. Now that's forced by the dissent, which sort of upsets what had been a fairly settled consensus as to whether incorporation can be really divided in this way. It's a doctrinal matter. So in some ways that it ends up, McDonald ends up being an odd case that on liberal for principles should have been a very easy case. But I guess that does go back to the notion that at least some of what's going on is political. On Andrew's point, I think you're quite right. I think that the process of 14th Amendment ratification, I think, speaks to some of the sort of what I characterize as memory-related issues. But the nation does not regard the 14th Amendment as unambiguous or an unambiguously good thing within its historical narratives. And I think that actually we've been talking about incorporation, but I think that's also ends up being quite relevant to affirmative action, and why we don't see more discussion of the Freedmen's Bureau in discussions by originalists about affirmative action. Well, one of the reasons is that, as I mentioned in the paper, I think it stands for illegality within a lot of people's minds. And finally, Garrett, on the citizenship clause, I think especially your point as to the politics of the citizenship clause is very much worth looking into, and it's a fair point, and I'll give it more thought.
Well, thank you very much.